Hello, this is Matt on the Moon Lambeau channel. In the SEC vs. Ripple case, we may have reached peak absurdity. Ripple's legal team crushing the SEC because they are absolutely not abiding by the court order indicating that they're required to share internal deliberations having to do with how they came to determine the legal status of Bitcoin, Ether, and XRP specifically, which of course is crucial to Ripple's fair notice defense, because if the court finds that, then Ripple indeed did not have fair notice, and I'm telling you they did not, but that's what the court finds. This case is over, Ripple wins, bam, that's it, done. But the SEC, they are currently being a bunch of baby-back biatches, and they are not providing anything that the court has demanded. And I do mean zero documents. They're claiming privilege. It's like, sorry, yeah, it's on the topic of what the judge said we need to hand over to you, but there's some stuff in here you can't see. Privilege, sorry, not going to give it to you. And so there's a new legal filing that attorney James Filan, an XRP community member, shared on Twitter late yesterday evening. And I've now had a chance to read through this whole thing. It's 8 pages. And so what I did, you can hear this here, I printed up this bad boy, and I highlighted the parts that were most relevant and interesting. Oh, and by the way, something that I was happy to see, it kind of surprised me, but we actually, for the first time ever in a court document, we actually did get some information about the William Hinman deposition. Not a ton, but there's like a couple sentences or so that I'm going to share with you in this video. And even then, I'll even tell you right here at the outset, like the SEC, according to Ripple's attorneys, not happy with how the deposition went down when Hinman was speaking under oath. So anyway, lots of interesting stuff right here, but I can't see how the judge is going to be okay with what the SEC has been doing, this behavior. Also, I'll be sharing with you opinions from attorney James Filan in this video, as well as attorney Jeremy Hogan. But before going further, I do want to be clear, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes YouTube videos purely as a fun hobby. That's all that's going on here, damn it. And so here's the actual document. And it reads as follows. Dear Judge Netburn, we write on behalf of Bradley Garlinghouse and Christian Larson and Ripple Labs to request a local rule conference to address the SEC's improper assertions of privilege. Principally deliberative process privilege, or DPP for short, which, by the way, is going to be referenced multiple times. So DPP, again, stands for, what did they say here? There it is. Deliberative process privilege, whatever, I got it. Over relevant documents that it has been twice ordered to produce and that are vital to the defense of this case. The SEC chose to bring aiding and abetting claims in this case against the individual defendants on the theory that beginning in 2013 for Larson and 2015 for Garlinghouse, and continuously from those points forward, the individual defendants knew or recklessly disregarded that Ripple's offerings and sales of XRP required registration as securities and that those transactions were improper, end quote. But discovery in this case has confirmed that during much of that same period, reasonable market participants and the SEC itself were still uncertain about whether or not digital assets generally, and XRP specifically, should be subject to registration under the federal securities laws. And so let me pause right there. This is true. This is absolutely true. And you should see in the document here, like the attorneys here, they wrote it in italics to emphasize this. Again, that market participants and the SEC itself were uncertain about digital assets and their classifications here. And it's true. The SEC absolutely, they had not, if you go back to the very beginning, it's cited in this document, the SEC had offered quite literally zero guidance. There were no public mentions dating back to the earliest portion of their charges against Ripple when they're saying Ripple should have known. And so it's just fascinating. And then they write, such evidence undermines any assertion that the individual defendants were objectively reckless in believing that XRP was not a security and that Ripple was on fair notice that XRP was a security. The SEC resisted defendants' requests to search for this kind of evidence, But on April 6, 2021, the court compelled the SEC to search its files for communications and documents concerning whether XRP, Bitcoin, or Ether is or ever was a security. And so let's pause here. Let's just pause here for just a little bit, to kind of talk about the importance of this here, because, again, the case is functionally over, and it's just like, it's clear. Here's the deal. It's very clear that there's something something important, maybe a lot of things important, that the SEC doesn't want to get out, and I do not believe for a moment that it's all about this privilege concern. Like, there's other stuff discussed within these documents that Ripple just can't see. I'm sitting here wondering, is it some sort of weird delay tactic? Is there a smoking gun in here? Because it's based on the judge responded to this point, I'm willing to bet that the judge will ultimately have none of this. But again, this is crucial to determining, is Ripple in the right or the wrong. It's crucial to their fair notice defense. The court has already determined this information is crucial, and the SEC is just stonewalling here. And so here's the thing. If they don't ultimately hand over documents that they're required to do, if the court continues to insist, no, this doesn't count under privilege, in such a situation, it can be the case that Ripple wins. It can be the case that, because you can have an ultimate, the judge can absolutely put down an ultimatum. Now, I don't think it's going to necessarily come to that, but I've seen attorneys within the XRP community talk about this idea, and so that would be extreme. I'd be very surprised if the SEC attorneys allowed things to go that way. But if they don't provide what they're required to provide, Ripple could just lose by or win rather by default. They could lose, so the SEC could lose by default. Anyway, it continues here. The court rejected the SEC's attempt to narrow its compulsion order in a second order on May 6, 2021. Intra-agency memoranda or formal position papers discussing Bitcoin, Ethereum, and XRP must be searched for and produced subject to a privilege assertion. And again, that's court order right there. The SEC represents that its review is complete, but it has not produced a single responsive internal document to the defendants. Instead, the SEC has served a series of privilege logs indicating that it is withholding all internal documents. And so check this out. You want to know what they're hiding? We only have very surface material, but here's what's cited by Ripple's attorneys. Among the materials the SEC is withholding are the following. They got 3 bullet points. And the second 2 bullet points actually have redacted information here. But bullet point number 1 reads as follows. 13 internal communications among SEC staff directly related to the regulatory status of Bitcoin and Ether over the period November 13th, 2013 to June 2018, including several specifically relating to the June 14th, 2018 speech by William Hinman, the then director of the Division of Corporation Finance, declaring Ether not to be a security. How about that? Doesn't that sound completely relevant? Doesn't that sound exactly like what was demanded by the court? Do you really, we're on the same page, I think, right? The SEC, they just don't want this to be used because it's not going to look, they don't want to strengthen Ripple's defense, but they have to. Second bullet point, part of this is redacted, unfortunately. 63 emails attaching drafts of Mr. Hinman's speech, each of which is asserted to be protected by both DPP and the attorney-client privilege, and each of which is described as an blank. It's redacted, unfortunately, so I don't know what it was. But how about that 63 drafts of Mr. Hinman's speech just being circulated throughout certain personnel within the SEC? 63 freaking drafts. He didn't write this thing himself. This was not solely his opinion. I don't care what he says. Other people helped him write it, so no, that is certainly not the case. He was consulted on what positions would make the most logical sense. This is very clear right here. Okay. And then the third bullet point, 6, and again, these are all things that the SEC is saying they have but won't give. And the third bullet point is 65 other documents consisting of emails, attorney notes, and memoranda starting in November 2013, for which the SEC asserts a DPP claim on 60. These documents have only brief and conclusory descriptions such as blank. And so unfortunately that part's redacted too, so we don't know what Ripple knows it has. Then they continue. Defendants do not know what actually sits behind the SEC's privilege assertions. What we do know is that in each case, the SEC has concluded that the relevant document is responsive to the court's May 6th order, which was itself confined to questions concerning the status of Bitcoin, Ether, and XRP under the federal securities laws, and that the documents evidence broad dialogue with the SEC and between the SEC and third parties about the regulatory status of digital assets, the period at issue for the SEC's scienter-based claims against the individual defendants, and its fair notice claims as to Ripple. Yeah, exactly. So it's clear that this is on topic, and the SEC just doesn't want to hand over the evidence. And when they're talking about scienter, that's that legal term that we came to learn. Like, fine, some of you out there listening, I'm sure, are attorneys. But for all of us that are not attorneys, scienter, not a word that I had ever come across in my daily life. But it's just this idea that, as it applies this case anyway, in order for you to have been guilty of something, there has to have been scienter, meaning that you would have had to have known, not just that you did something wrong, but that you knew that what you were doing was wrong, and you have to prove that. Or in this case also, there could have been reckless disregard. But, these are high bars. It's to prove this sufficiently in court. Like, these are actual high bars, and good luck, SEC. You're going to need it. And then they write, the SEC's blanket invocation of DPP is untenable. DPP is a limited and qualified privilege that cannot justify the SEC's withholding this broad swath of relevant documents in the context of this exceptional case. So for these reasons, defendants respectfully request that the court find that the SEC may not invoke DPP with respect to the categories of documents covered by the court's April 6th and May 6th, 2021 orders, and therefore compel the SEC to produce those documents responsive to its April 6th and May 6th, 2021 orders that are withheld on the basis of DPP. So pause right there. To clarify, all Ripple is saying here right now is, hey, Judge, please make the SEC do what they were already ordered by you to do. That's what they're communicating. And then they also wrote the following, which is even more interesting, and I'm not 100% sure what the implications of the following would be, but check this out. And the alternative, the court should require the SEC to produce the withheld material for in-camera review. Defendants do not make this request lightly, but given the vital importance of these documents to their defense, it is critical that, at a minimum, a neutral arbiter test the SEC's sweeping DPP claims, particularly where individuals stand accused of failing to accurately predict the law several years ago before the SEC itself elected to bring this lawsuit. And so as far as the in-camera part, I'm not sure exactly what that means, but they are talking about the idea. So if the court is not going to any longer enforce that the SEC has to hand over what they've already been court ordered to hand over, they're proposing that in lieu of that you have an arbiter, a neutral party, come in, take a look at this information, and then determine whether or not these DPP claims that the SEC is making actually stand to reason. And I have a very strong suspicion that if you have somebody who's truly neutral, it's not going to stand. Come on. Do we really believe there's not one freaking document in all of the SEC's internal communications that can be submitted to Ripple? Does anybody actually believe that? Come on. We've got more than half a brain here, do we not? Then Ripple's legal team also wrote the following. The SEC has charged 2 individuals with scienter-based offenses in what nearly every court and legal commentator to consider the issue acknowledges is still an exceedingly complex and unsettled area of the law. So let me pause right there. That's why I was saying with scienter, that's the part that's key here. This is an unsettled area of the law, even though Gary Gensler and all of the asshats over at the SEC, not all of them are claiming it, but the ones that are, they're insisting that there is sufficient clarity. And of course, you get to your Elad Roismans and Hester Purses, but outside of those 2 commissioners, it just seems to be the SEC's position that no, we already told you what you need to do. It's fine. Whatever. It's a ton of you, an endless number of you have questions, or you're requesting legal clarity surrounding the space. We don't have these questions with other asset classes. That must be your fault. We've provided the clarity. You guys must just be stupid operating in the space. There's something about that. Does that make logical sense? And then they wrote the following. Indeed, in just the last few weeks, 2 sitting SEC commissioners have publicly stated that even today in 2021, quote, there is a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading, end quote. And a sitting commissioner on the Commodity Futures Trading Commission has publicly disputed the sitting SEC chair's assertion of regulatory authority over all digital assets. Yeah, and I actually highlighted that in a previous video just a few days or so ago. It was just fascinating. I'm like, it's like everybody that is not beholden to the SEC, like anybody that's not biased, which basically means anybody outside the SEC, anybody that's not biased can see that the SEC, they don't have the power over this asset class that they're saying they do, and we can also see that there's not sufficient regulatory clarity. Everybody else can see this. It's clear. Right? This is not something that should be disputed, but the SEC does dispute it, and my gosh, the cojones, right? Like, I don't know how much longer they're going to be able to get away with this, though. I really don't. And then they wrote this. Oh, check this. This is the William Hinman portion. We got just a little taster. I do suspect more is going to be coming out as time passes, but this is the first little snippet we got of anything. So hey, you know what? I'll take it. The SEC appears to be invoking the attorney-client privilege to shield communications that go far beyond what the attorney-client privilege would protect. For example, during the deposition of Mr. Hinman, the SEC's counsel directed the witness not to answer a question regarding his communications with former SEC Chairman Jay Clayton leading up to the June 2018 Hinman speech on the basis that both are lawyers, despite the fact that both held policy positions, and the question called for a discussion about policy, not legal advice. And so here you go. Not only do they not want to hand over documents that the court has ordered they have to hand over, same approach when it comes to getting questions answered for Mr. Hinman, just more stonewalling, pretending like, no, can't do that, privilege, blah, 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 this or that. They don't want any real information out because it would reveal the truth, I believe, which is that the SEC knows that what they're doing is wrong, and they don't even believe the arguments that they're making. I don't believe that they believe the arguments they're making. It's completely illogical. Hypocrites, bunch of hypocrites. These are not good people. They really are not good people. And so then there was this short thread on Twitter in response to the tweet where Attorney James Filan was sharing this initial document, which I just ran through with you. Somebody responded with the following. I'm curious as to why Judge Netburn has not done anything about the SEC not turning over documents that were ordered to be turned over by her. This seems fishy to me. Does she herself, Judge Netburn, have an agenda that we, the people, don't know of? And then somebody else wrote, I have yet to hear a reply as to why she allowed this. If it was Ripple refusing to provide twice court-ordered documents, then she would have sent in the feds to force them by now. It's because SEC are a government agency, so judges give them special extra judicial privilege. And this is where James Filan actually jumped in and shared the following. The short answer is, judge-ordered documents produced, quote, subject to a privilege assertion, end quote, and said, quote, documents withheld on the basis of privilege must be identified on a privilege log, end quote. The SEC submitted privilege logs claiming everything is privileged, and Ripple is calling BS. And so, and rightfully so, which is why, just based on how the judges responded in the past, I have a feeling that the response will be favorable to Ripple, but we'll have to wait and see exactly how this unfolds. And then Attorney Jeremy Hogan said the following about this. The SEC has listed over 300 documents on its privilege log, but all of them are privileged with 2 question marks. These privileged, in quotation marks, privileged documents include numerous documents related to Director Hinman's 2018 speech, which the judge has already indicated she finds extremely relevant to fair notice defense. Exactly, which is why I'm sitting here looking at this, and I'm just like, do we not think that the judge is going to continue to enforce this? Like, of course she is, right? It seems that way? I mean, fine, technically, we don't know for sure. I'd certainly be surprised, because that would be quite the 180, wouldn't it, in terms of position on this? So we'll see. And then somebody asked Jeremy Hogan, why is Ripple's lawyer not lodged an official complaint on this to the judge? I thought she previously said raise it officially if you think it's a problem. And Jeremy responded with the following. That's essentially what this brief is. What confused me is why it took almost 3 weeks to file when the judge basically asked for it back at the last hearing. Yeah, and so I've been wondering that too. I don't know. None of us know. Like, what's with the delay? I mean, there has to be a good reason. Like, these are top shelf lawyers working on behalf of Ripple, so there has to be a reason. But like, even Jeremy Hogan in speculating, from what I've seen anyway, it seems like he's very curious and also doesn't have a clue. It's just I don't know what that could be, but I have to imagine that there's some sort of good reason, and not that they dropped the ball, but who knows? Maybe they messed up. They could have. Let me know what you think below, but I just find this all repulsive, and I'm still optimistic that this is going to go well for Ripple. Very much looking forward to seeing the judges' response. Hopefully we'll have something within the next few days, but we'll see. The drama keeps unfolding. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.